This is another poster in the Rookie to Rainmaker series that's included in the Rainmaker Toolkit. What the heck is hearsay? Hearsay is a concept that most people have trouble understanding. I used to teach trial practice at Stetson University, and not only did my students not understand it, but in 40 years of practice, I've discovered that a lot of judges don't understand it either. It's testimony or documents quoting people who are not present in the courtroom. Evidence is testimony. It's also documents. We all know this. Hearsay is not just testimony. It's also documents. Documents that communicate a concept, say something, declare something. So a declarant is the person or the document who originally said or wrote the hearsay, who declared the hearsay. That's a word that a client might hear, and so you might want to explain that to him. That's why it's here in the poster. Hearsay is inadmissible, meaning that a judge can't let it into court, into evidence. And inadmissible is another term of art that you need to explain to your client. Remember, your clients are being stressed. They're in litigation. This is not a familiar venue for them, and you're using all these words they don't understand. So help them understand. This poster is a very visual representation of these concepts. It makes it easier for clients to understand, especially if they are visual rather than used to using the written word. So the question becomes, why is it inadmissible? Well, it's inadmissible because the opposing party can't cross-examine the person who said these words to begin with. So can't prove or disprove the credibility of the declarant. It's all about credibility. The person who is not in the courtroom can't be cross-examined. And then here I explain further, hearsay evidence is inadmissible for lack of a first-hand witness. That's another way of saying the same thing. You don't have someone firsthand in the courtroom who can talk about the event that's being described or the emotions that are being vented or what have you, the testimony. Now, at the bottom of this poster, I have a list of exceptions to the hearsay rule. These are not all the exceptions. There are probably 21 or 22 in Florida. Other states are probably about the same. There may be some distinctions, but I've picked 7 of the most common exceptions, things that are outside the hearsay rule. So yes, it's hearsay, but it can still come into court because it's especially credible for some other reason other than proving up the credibility of the speaker. You've got, for example, statements describing an event or condition like, look at Sarah, she's trying to swim to the boat. Excited utterances, oh my God, that car just ran the light. Statement made for medical diagnosis, that's a very common one. It's especially credible because you're not going to lie to your doctor. You want to be fixed. You want to be cured. Whatever the problem is, you want your doctor to fix it for you. And so those statements are especially credible. You can see the rest of the exceptions. I've given not just the exception, but an example of a statement that would fit in that category to make it easier for you, the young lawyer, to not only understand hearsay and its application yourself, but also to explain it to your client who is really, puttering around in the water, hoping not to drown in this thing called litigation, that you can really help them feel more comfortable that you know what you're doing and that they know what they're doing.